Many of you will be aware that Community Law and Mediation launched our Centre for Environmental Justice in 2021. And so environmental justice is essentially the intersection of social justice and environmentalism, or in other words, the protection of both people and planet. And the Centre works on bridging that gap between environmental and social justice issues. And this includes bringing an environmental lens to issues like substandard housing conditions, energy poverty, poor mental and physical health, and inadequate access to services such as transport or amenities such as green space. And ensuring that everyone has awareness of their environmental rights is a really critical aspect of this. And so we especially welcome those joining today who are completely new to this area. We hope that the information provided on the Aarhus Convention might provide new insights in thinking about how both environmental and social justice issues can be addressed in a holistic manner. And over the course of the 3 webinars, we will be answering questions such as, why is access to environmental information a critically important right? What does public participation in environmental decision-making actually mean? And when is it necessary to bring legal cases to protect environmental rights? And then in that case, who actually gets to go to court? We are very grateful today to the Community Foundation of Ireland for funding this training series, and especially to Eoin Brady and Niall Sargent, our expert speakers who are joining us this morning. There will be space for questions at the end of the session, so please do use the Q&A box at the bottom of your screen to ask any questions you might have. If you happen to see a question similar to one that you would like to ask, you can upvote that question using the thumbs up icon, and that will make any question you have more likely to be addressed. As this is quite a short event and we have a lot to get through, I'm not going to take up any more time. So I'd like to introduce our first speaker this morning, Eoin Brady. Eoin is a partner with FP Logue Solicitors who specialise in environment and planning, data protection and information law. Previously, he worked for a large commercial law firm where he advised public sector clients on AIE, and as senior solicitor with EirGrid, the national electricity transmission operator, where he was responsible for oversight of a large volume of AIE requests. He previously worked as an environmental lawyer on forestry policy issues with Client Earth in Brussels, and he has a master's in environmental law from Queen's University in Belfast. So I'm now going to pass it over to yourself, Eoin.
Thanks very much indeed, Clodagh, and I'm glad to be here this morning to talk about access to information on the environment. It's a really fascinating area, and sure Niall will have more practical examples from his work. Probably nobody does as many, I'd say, AIEs as Niall. But I'm just going to speak a bit about maybe what access to information environment is initially. I might just try and share my screen, if that is okay. I'll just try and make sure you can see that. Can you see that there now? So basically, I'm going to start off just briefly, a brief description of what AIE is, and then I'm going to move on to look at what type of information can be requested, and I'm just going to finish up then with some case law examples. Just bear with me there 2 seconds. Difficulty trying to move on here with this. Okay, so yeah, so basically just the story of AIE really begins in Denmark, in a city called Aarhus. Some of you might have heard of, and this is really where everything that we're dealing with this morning really came from a conference that was held there, where a convention on environmental rights was made in 1998. Basically, it's from this that the European Union then took its cue to bring in a directive that provides for access to information on the environment, and then Ireland transposed that into our own domestic regulations. So everything that we're talking about this morning really starts there, and because the EU has implemented this into EU law, access to information environment, that gives it an additional status, we'll say, within Irish law, and it's created some interesting case law as a result. So just briefly, a lot of you probably have heard of what the Aarhus Convention, but fundamentally what it's about is contained in Article 1, where it says that in order to contribute to the protection of the right of every person of present and future generations to live in an environment adequate to his or her health and well-being, each party shall guarantee the rights of access to information, public participation in decision making, and access to justice in environmental matters in accordance with provisions of the convention. So that just sums up exactly what the Aarhus Convention is about. There's, if you can see from that Article 1, there's 3 different basically pillars, as we call it, to the convention. If you think of it like a 3-legged stool. So what the Aarhus Convention is about is this concept of environmental democracy and public participation. So there's 3 elements to that. One is that members of the public have access to information on what is going on around them in their environment. And that's the key thing, and that's what we're talking about this morning. So that's the first pillar, is that basically before you're able to participate, you need to know what's going on. So that's critical. It's the first fundamental concept, access to information. Building on that then is once you have that information, then members of the public can properly participate when they're armed with the full facts of what is going on in relation to a particular project, particular plan, and so on. And then they can get involved in that process that the state would lay down. So really what we're talking about in an Irish context could be like planning permission, it could be an EPA license, water pollution license, etc. And then the third aspect is that once that decision is made on that particular plan or project, that the members of the public that have participated have a right to an independent review process to challenge that decision, to make sure that it's been taken in accordance with law. And that is what we call the access to justice element or pillar of the convention. So basically, what is access to information environment? So there's 3 aspects to it. There's one is where you make a direct request to a public authority. And then there's also a set of obligations on public authorities to organise and disseminate environmental information and to progressively use electronic means to do so. So in other words, it's not just good enough that people like yourselves on the call this morning have to put forward access to information on the environment request, but public authorities should be proactively disseminating information that they have, putting it out there on their website, making it available to members of the public. And that is a key thing that is kind of often overlooked in terms of AIE. And then the third aspect is that basically where there's an imminent threat to human health or the environment, there's an obligation on public authorities to make the relevant information immediately available. You don't have to be waiting a period of 4 weeks, as we'll see. So what is environmental information? And there's quite a complex definition of it. I'm not going to spend a whole lot of time this morning dealing with it, but basically there's a number of elements to it. The first thing is that it's information and as opposed to records. You see on the FOI legislation talk about records, but environmental information is information in any form, written, visual, oral, electronic, etc., on the state of the elements of the environment. That's the first thing. Or factors affecting or likely to affect the elements of the environment. So we're talking about there like substances, energy, noise, emissions, and so on. And then measures affecting or likely to affect such elements and factors. So the third element of the definition is linking back to the previous 2. And then the fourth one is about reports on the implementation of any environmental legislation. The fifth then is economic analysis used in the framework of measures on the environment. And then the last one then is a state of human health and safety and conditions of human life. So you'll immediately see that it's really, really wide ranging. And that is very important from a practical point of view, that the concept of environmental information is not necessarily what you might immediately think is environment as such, but it may be something that is related to an environmental measure or activity, and thus is then captured within the regulations. So basically, there's some key concept within the regulations. There's the definition of a public authority, and again, that can be quite wide-ranging because it can actually be a private entity in some cases that are exercising public functions. there's as I said, there's this proactive duty on public authorities to disseminate environmental information, and that includes an obligation to actually train their staff in how to implement AIE. Now that is often not implemented. There's a lot of room for improvement on that score. I'm sure Niall has plenty of examples of that later. There's also a duty to assist applicants that, like, where something's not immediately clear and so on. The public authority just can't say, look, we don't have it or whatever. They're supposed to help you, to guide you to accessing the information, and that's a key concept in this. That it's not it's about the intention behind the regulations. The intention is to give people information and get them information. So this kind of stonewalling that you often see with public authorities, that is not actually allowed under the under the regulations, as we'll see. As I say, there's this very wide definition of environmental information. There was a case here a number of years ago called Minch and the Commissioner for Environmental Information that has opened up AIE and broadened it out massively in practice. So it's great. It's a great tool in the armory, people that are interested in the environment, to get the facts behind the headlines and so on. There is an exclusion that basically a request for environmental information can only be granted where that information is not otherwise made available. So this idea that in the first instance public authorities should be putting it out on the website, and then that gets away from them having to go through the whole kind of rigmarole of individual requests. So there's a number of exceptions. I won't go into them in too much detail, but just to be kind of aware of them at a broad level, there's called mandatory exemptions, and then there's discretionary exemptions. The mandatory exemptions are where there is an adverse effect, and that's a key thing, that there must be a demonstration that there would be an adverse effect from the release of that particular information, and not like just whole categories of information. It must be specific to the particular information requested. So you've got an adverse effect on personal. That's the sort of the privacy issue. Material supplied by third parties where they were not under an obligation to release that. Protection of the environment itself is actually a reason for not giving out information, and the confidentiality of the proceedings of public authorities is another. And then there's discussions at meetings of the government. There's then, apart from the mandatory exemptions, there's discretionary exemptions, and these are quite tightly controlled because they have to be basically looked at from the concept of once an exemption is applied, you have to satisfy that the public interest is satisfied, requires the withholding of the records, and that is something that's an interesting factor in things. So again, you have to show that there would be an adverse effect on international relations, national defence, or public security, the course of justice, i.e. legal proceedings, commercial or industrial confidentiality, that's often a tricky one, intellectual property rights, and then there's what we call administrative grounds for refusal, and that's like material in the course of completion where a public authority is preparing to come to a decision, and they're just in that sort of discussion process internally. That can be a reason to withhold, but they're still obliged to release that once that process is complete. Then another one is internal communications of public bodies, also quite tricky in practice. And then where the request is manifestly unreasonable or too general in nature, that is one that that is to be mindful of when you're making a request, that you tailor that request in such a way that can't be thrown out on the basis of that exemption. So you kind of really think about your request before you send it, so you have it tailored. So just in terms of some miscellaneous provisions, there's a particular restriction on exemptions where basically there's emissions into the environment. So if there's actually if the information is in relation to emissions into the environment, so it could be carbon emissions, it could be where there's water pollution going into a river and so on, that is very tightly controlled under the regulations in terms of exemptions, because there's a presumption that type of information must be released, notwithstanding all the factors such as industrial confidentiality and so on, that the fact that there's emissions trumps those other interests such as commercial interests and so on. as I said, there's a core concept of the public interest that even if an exemption was on balance found to apply to a particular set of information, you must apply the public interest test. Is there a public interest in that information being released, even notwithstanding those other interests, such as commercial confidentiality and so on? And as I say, there's a presumption in favor of disclosure. And that's, as I said, is a core issue, as a core concept behind the regulations, and really something to bear in mind, that when you're making your request, you have it in your head, I'm entitled to this information and I want to get it. And I want to know, if you're going to stop me getting it, I want to know exactly why. And you're going to tell me how the reasons are justified in accordance with the regulations. So in relation to that concept as well, that where information is being withheld legitimately, the public authority is obliged to not just withhold a whole lot of it, but only those bits of that information where that exemption is found to apply. So if the rest of the information can be granted, it must be released. So basically, as I say, if the material is in the course of completion, it's not good enough for the public authority just to say, look, but this is in the course of completion, good luck. They must tell you when is it going to be finished, and give you the opportunity to get that information. And it has to be obviously reasonable time. They can't say, oh, we'll do it in 2 or 3 years or so on. It's not, that's not allowed. So it's all this core concept has said that information must be proactively released when it's environmental information. And then there's this concept of deemed refusal. So if the public authority doesn't respond to your request, and that often happens, basically it's deemed to be a refusal, and that gives you the opportunity then of appealing and so on to the Information Commission, the Environmental Information Commissioner. So as I said, when you're dealing with the regulations, just remember, this is coming from EU law. It's a purposive approach. It's basically information must be released, and bear that in mind. So when you're being stonewalled, as you often will be at first instance by a public authority, that you keep on it, and look, more than likely you're entitled to that information. You just, perseverance is the key thing with AIE. So the whole concept is about that. As I say, this three-legged stool. It's about getting that information that allows you then to participate in the environmental decision making. And it's not just maybe in relation to, information that you get today can be very valuable in years' time, 2 years' time, and so on, particularly where you're dealing with an ongoing sort of pollution event and so on, that you're building up a picture, and how that public authorities, how the state agencies, be the EPA, could be county council, so on, are responding to that particular environmental concern that you have in your area. As I say, it's a broad right of access, but it's not unlimited. As I say, the exceptions are there, but they are to be interpreted restrictively. And where the exception is engaged, the public interest must be considered. And then, as I say, exempt information to be separated out, and partial release can be granted. And each piece of information is to be considered separately. So it's not just as good enough, as I said, to say, well, this is a whole, this is to do with a wastewater treatment plant, and it's a matter that's under consideration, and we're going to withhold all that information. That sort of blanket exemptions are not allowed. The public authority must specify for each piece of that information how that exemption applies, and justify it. So as I said, the overriding public interest is on, there's an overriding public interest where there's emissions into the environment, that that information. So bear that in mind. So always kind of one of the first questions to ask yourself when you're putting in an AIE request is this actually related to actual emissions into the environment? And there's quite a broad definition of what emissions are. So just a quote there from some of the case law. It was a case there a couple of years ago, Right to Know and Right to Know are a group of journalists that have kind of formed together and make a lot of AIE requests about specific areas, and trying to move the law forward, the case law forward. Have been quite successful in that regard. Where the judge said, the fact of the matter is that the directive and the AIE regulations provide for a fundamental right of access to environmental information. That's from the courts. That's what the courts are saying. So it's not just me. This is what that you're entitled to, and that's why it's really good that you guys are on this morning and trying to find out about these regulations, because they're really, really powerful as an instrument. Again, the same case where the judge said that any decision on a request for environmental information must reflect the fact that the process of engagement with the request, whatever the ultimate outcome, was conducted in accordance with the letter and the spirit of the directive. That's very important, and it's very important in practice. And so that the public authority must demonstrate not alone that they're just following the law and maybe applying exemptions, but they're actually doing so in the spirit of the directive. So I just want to talk a bit about how this might how AIE has helped me in practice. And it's been AIE is just a core critical part of my work across everything, because it's just so powerful, as I say, and about getting information. I just want to use this particular example as how AIE has helped and brought about, I suppose, results in practice. And so some of you might have heard of, there was a situation down in Roscommon last year where basically there was a proposal by Roscommon County Council to build a pipeline from a turlock called Lough Finchina, which is about 4 kilometers west of Lough Ree. And both Lough Finchina and Lough Ree are what we call special areas of conservation. They're Natura 2000 sites under the Habitats Directive. So they're prime habitat for various species and also birds in the case of Lough Ree. And Lough Finchina itself then is a noted wetland for whooper swan and different types of birds. So basically, it was this big project where there had been serious flooding in Lough Finchina, because it's a turlock is normally a lake that goes up and down. So it goes up in winter when there's lots of rain, and then recedes in the summer. And this is kind of what gave it, its status as a protected site. And basically, however, it stopped working in the normal way it would normally do, which would recede in the summertime. It just kept increasing, and people's houses got flooded quite badly, and there was people were going to have to leave their homes and so on. But the key thing was that in Roscommon County Council obviously saw this as an emergency situation, but they had to comply with the environmental laws that were there in terms of the Habitats Directive. There was a particular procedure that they could have applied to undertake a works to reduce the level of the protected area. But they had to do so in accordance with a particular procedure under law. But basically, our client was Friends of the Irish Environment, and they got wind of this. I think it was the August bank holiday weekend of last year. I was actually on holidays myself, and I remember getting when this came in. And basically, the first thing I did was I sent out a number of AIE requests. I'll come through those now in a minute. But this is just this was actually a photograph taken on that August bank holiday weekend with a drone, just showing that the works that were currently underway. So you can kind of see Lough Ree just in the far distance there. So that this pipeline was to go all the way along there at the time. So again, I sent out a number of AIE requests that August bank holiday weekend. I sent one to Roscommon County Council, one to the National Parks and Wildlife Service, one to Office of Public Works, and one to Geological Survey Ireland, who've been working on this lake with Roscommon County Council. Now, it was really kind of in the dark about everything, because everything was being done sort of clandestinely. There was no information made available public, but I kind of figured these guys would know something. So I kind of sent them all this kind of same generic type of AIE request. And basically, the Roscommon County Council and the Office of Public Works refused the request, but National Parks and Wildlife Service and Geological Survey Ireland actually dealt with it. And I'll bring you to how that was actually useful from my point of view in due course. So basically, we went in with an injunction in I think about the 10th or 11th of August. So about a week after we found out about it, we went into court with an injunction to stop those works, just shown in the previous photograph. And we got our injunction effectively that stopped the works, and we got that on the 25th of August. Roscommon County Council just kind of conceded the case on consent. They admitted that they didn't have any legal basis to do what they were doing. So they're basically using an act from 1949 before we joined the EU to do these particular works. And there was no like environmental assessments whatsoever done. So it was completely illegal what they were doing. And then basically in October, we thought everything was done and dusted at that point. That was, they go back to go back and you know, do things the proper way. There's a process, as I said, you could apply to An Bord Pleanála for what's called imperative reasons of overriding public interest. So you can undertake a project that would do some particular damage to a habitat, but it's in the overriding public interest. And that process was available to Roscommon County Council to do that. But basically in October, on the 14th of October of last year, the council went ahead with a different scheme. And basically, because I had done these, I'd done various requests under AIE. But the main one, as I said, that I did to Roscommon at the time, they refused for the first one, but I did subsequent ones. And one of them that I got later on transpired, it was an email that was sent out at approximately 12 o'clock on, sorry, it wasn't an email, it was a meeting invite. It was sent out at 12 o'clock midday on the 25th of August from the secretary to the chief executive of Roscommon County Council to their consultants, basically, and the meeting invite subject heading was meeting discuss path for moving forward with works at Logue Finchna. Now, the court had only ruled at 11 o'clock that the works were illegal, and they were already, we found out later, just kind of going to motor on and keep going. So it was kind of just interesting to get that meeting invite on their AIE. And then as I said, we sort of cast the net wide. And one of the interesting things that came back was that there had been a previous meeting between the National Parks and Wildlife Service and that kind of heads the leadership management of Roscommon County Council, in which this was prior to the works ever taking place. And basically, it showed that the National Parks and Wildlife Service had told Roscommon County Council that they had to go and do this overriding public interest application to An Bord Pleanála, and this was quite critical in the subsequent legal proceedings that happened. And this is record 26, and this was sort of this was a key record that we had that demonstrated. It was the meeting minutes of that, at which, as I said, the Director of Services for Roscommon County Council, that was what was, you know, one of the main people involved in the whole thing, was told this in no uncertain terms. So then there was quite interesting things then in terms of the actual way the case played out. One of the things was that the chief executive of Roscommon County Council said that the Turlock, this issue of the lake, that it wasn't actually a Turlock, and this because the fact that it was a Turlock gave it this designation under EU law. So he said that it wasn't a Turlock because there was no interaction between the groundwater that sat below the Turlock and the Turlock itself, right? So he said his words were as perched above, and I just showed some of the paragraphs from his affidavit that he had in court. But because we had done all these AIE requests, we were able to show an email from, again, it was January 2021, and the work started that later on, a couple of months later in May 2021. But there was an email from one of the head guys in Geological Survey Ireland to the senior engineer in Roscommon County Council. So the senior engineer asked the Geological Survey guy whether there was what he called a hydraulic gradient across the lake. Basically, was there some kind of flow across it? And the senior scientist in the GSI responded back that basically that in his view that there was a probability that there was upwelling coming from below the groundwater, below the Turlock, from the groundwater, that was causing the flooding. And so this was directly contradicting what the chief executive had put on affidavit. And again, it was going to be a very significant issue in terms of the legal position that Roscommon had taken to justify the works. So again, another interesting thing that we got under AIE, now this was actually just a meeting minute, but basically 14th of October was the deadline set by by Roscommon County Council to undertake these works. And there was a meeting called for Roscommon County Council of their members at 2:30 on that day. And basically the chief executive of Roscommon County Council had signed this order here, and I've just taken an extract from it, right? And it basically, this was the order that Roscommon were giving to themselves to basically undertake these new set of works. And as you can see there, he said that has read and considered, and at the very bottom, the bottom two bullets there, screening for appropriate assessment report to Malachy Walsh of October 2021. Now, it doesn't give a date, interestingly, and then screening for environmental impact assessment report of October 2021. So this was the chief executive's order that we got. I think we got this under AIE as well. And basically, this is the official minutes that are on Roscommon County Council, and records the meeting starting at 2:30. And then the Director of Services, Shane Tiernan, outlined the details of the chief executive order signed this afternoon. So implying that it had been signed at 2:30. So then basically we did more AIE requests, and we got this email which showed that basically the Malachy Walsh and Partners, which were the consultants to Roscommon County Council, sent the EIA report at 17:23 on the 14th of October, which showed that basically the chief executive could not have read and considered the report, because it had been he had said that he had signed it before 2:30. It didn't arrive till 23 minutes past 7. Sorry, 23 minutes past 5. And this was a sort of a game changer, really, in terms of the legal position, because the legal position is obviously that you must have considered the environmental reports before you come to a decision. So again, in that regard, we got a ruling from the court, basically, that the works were effectively to stop. So it was quite a significant thing. But basically, AIEs were really critical in getting us that decision for Friends of the Irish Environment. One just postscript kind of thing was on it. If you remember going back, Roscommon County Council, they refused me the first one, which was basically all correspondence between them and the OPW and Minister Patrick O'Donovan and so on in relation to it. And I had to take that to the Office of the Environmental Information Commissioner on appeal. They resisted that. But just almost a year later, it was 21st of July, I got the decision from the Commissioner and directing Roscommon County Council to go back and get to basically answer my request. And I just got the files there in the post in the last couple of days, and there they are. I still haven't gone through them. But it just shows you the power of AIE. So there was a lot of resistance giving me that information, but perseverance, and we got there, and we've got those files, and we've got the information that is there. And there's just two Hooper Swans there on Lough Finchina itself. So I'm going to have to hop off. I have to go to court for a few minutes, virtual court, but I'll be back for the Q&A session with Niall in a few minutes.
Thank you so much, Eoin, for such a comprehensive overview of the Irish Convention in general, but also of how important AIE is and how important it's been to the legal work that FP Logue does and that Friends of the Irish Environment do as well. So thank you so much. I see there's some questions already coming into the Q&A box. So I'd encourage people to keep them coming. We will have time for those at the end, but now I'm going to hand over to Niall Sargent. So whenever you're ready, Niall.
Mute myself first. I'll share my screen now. Thank you very much.
Thanks.
So just get this. Perfect. So can you see that coming up full screen for you then? Perfect. Good. So yeah, thanks very much for having me. It's really interesting. I think there's a few more journalists who send just as many AIEs as me, and I hope Eoin wasn't on the receiving end of some of them at AirGrid. He probably was. So what I'm going to do is I'm going to talk for about 20 minutes, hopefully, on access to information environment, or AIE, as I'll call them, requests, and the experience from myself, but from where I'm working currently as an investigative reporter at Noteworthy. And then, probably more importantly, I'm going to try to get through the examples. I'll just give one or two examples of recent use of it and how important it is. But the most important thing, I think, is to give you a few quick tips on actually sending a request yourself. So the very practical, basic things to do: typing it in and pressing send for the email, and then fingers crossed, hopefully getting what you're looking for back. So this is just, so if you're not aware of Noteworthy and how we work, so this is why I think this this talk or this event is really important for me, because we're very community oriented as well. The way we work is we crowdsource ideas from members of the public about stories that they think are underappreciated and deserve reporting. And then we put those, if we see value in it, we will put together a proposal and put it out for funding, and then back out to the public. So it's crowdfunded. So the ideas are crowdsourced, and then the investigations are crowdfunded, and then we go off and tell those stories, hopefully. And the very interesting thing is that in many cases, what gets funded lately are environmental stories. So even if I don't want to do them or get away from the environmental area, I can't really help it, because that's what people are funding for the most part lately. So we've done lots. These are just 4 examples I put up here of varied investigations we've done recently where we've used AIE, from stuff on carbon emissions, overgrazing on our protected areas, from irregularities in the poultry litter trade on the island of Ireland, cross-border stuff, and also spraying of pesticides and herbicides by public authorities on public spaces. So we've used AIE in all those, but honestly, I've used AIE in probably at least 10 investigations that I've been working on recently. Just one of the reasons, I think, to tell you why it's, I suppose, important to have the AIE is there are plenty of roadblocks when you're trying to do environmental reporting. So, you know, the key one, and Eoin touched on it, is this lack of transparency on the decision-making process. There's also, you know, lack of publicly available data or information. There's also restrictive decision-making on FOI requests, which is like the freedom of information. It's the bigger brother or cousin of AIE requests, but it is more restricted. There are more exemptions, and Eoin made, you know, the very good point of the connections that AIE has to European and UN laws and the Aarhus Convention, which give them much stronger legal standing, and there are less exemptions then, and there should be greater access to information because there's much more limited FOI. So these are problems you face as a journalist trying to tell these stories. The key ones, the lack of transparency on the decision-making process and actual lack of the information being available when it should be. So I'm going to give you 2 examples of what we've gone through. Sorry, is the bar coming up across the presentation for you guys, or can you just see the presentation screen?
No, it looks good now.
Oh, perfect. Just for me then. So the main, probably recent example of where AIE has been incredibly important to the investigation is a 10-part series we did on unlicensed large-scale peat extraction or industrial peat extraction across Ireland. The example we have here, it's not the great, it doesn't really tell you because it's the more traditional image, but people associate the images of the cut turf like that. So you'll see why it's a little different in reality. But essentially we wanted to find out, you know, why have authorities allowed this to go on when we know it's an unlicensed industry for so long? Because we have this perception in Ireland, the perception that someone is going out cutting it by hand and we're, you know, stacking it as we used to traditionally, which has a lesser, still an impact, but obviously a lesser impact than the reality, which is large scale industrial processing of peat in the Midlands. And if you just look on Google Map over the Midlands, the reason it looks brown in the center of the country is because of this sort of industrial scale peat extraction activities. For this particular product, which, you know, peat is great as a carbon for climate and biodiversity reasons. It's a carbon sink. It holds perfect conditions for rare species of sphagnum moss, other flora. It's a great breeding ground and foraging ground, breeding ground for endangered or protected species in Ireland. Great flood retention, just fantastic overall. Yet we decide that it also has this very great property that we can burn it or we can use it in the horticultural industry. So we've been extracting it for decades. So in doing this investigation, again, like I said, the key issue we always face in investigative reporting on environmental issues is a lack of public records. This was a massive problem in this investigation. No extraction data because it's an unregulated industry. No real import or exportation data of peat, apart from CSO have very good general data, but they don't have specifics on companies. So we don't know who exactly is extracting the most. There's no real planning files. There's some auxiliary planning files for the likes of a peat processing facility. So some companies will have, this is the ironic elements of this thing, there'll be planning permission for a peat extractor, peat processing facility, but there will be no planning permission or licensing to extract the actual peat itself, but companies will have. So there'll be no planning files for the actual extraction. Therefore, there's no public enforcement files because there's no planning file. And this, I went through these Kafkaesque decision-making processes where I would be asking authorities, can I have details of the enforcement cases against particular companies or against any peat extracting companies in your county? The county councils would reply, well, we need the planning file number first. And I would say, well, we both know there's no planning file number because they don't have planning permission, but they should. And then they would tell me, well, in that case, we can't provide it because if we gave you the enforcement records, there could be a legal issue there. So my whole argument, of course, is, well, if they had planning permission and they were doing something illegal or breaking conditions, all your correspondence, all your letters with them, all the warning notices, enforcement notices would go on your website. But because they didn't go and get planning permission like they should, you're telling me you can't have the record. So it's a very frustrating process. And this is where access to information on the environment really came into effect. Sorry, they're a bit blurry. I just don't want to show you necessarily all the details on these, but this is just to show you, I always make Excel spreadsheets for the different investigations for requests. So in this request, I made 71 access to information on the environment requests. There's a few FOIs in there, but it was predominantly access information. So, you know, it's a lot. No one is expecting any normal or sane person to go out and make 71 requests in the space of a few months. Certainly some of the public authorities wish I did not, because I was getting a little annoying to them. But without these requests, I wouldn't have been able to tell the story. Through these requests, I was asking for the likes of inspection reports from counties that I know have particular companies, that large companies based in them. And I was asking for stuff around like historic cases of planning permission files or enforcement notices, asking for like if there was any images or photos taken from inspections, asking if there's any internal reports from different departments on like the legal framework, how many companies were known to be operating without the licensing, etc., to trace back how far this issue went. And we got really lucky that I knew, you know, the EPA were looking at certain companies, and through AIE requests to the Environmental Protection Agency, I'm looking for, say, site inspection reports or inspection reports against a particular list of companies. I got back these incredibly detailed investigative reports against two of the leading peat extraction companies in the company. One, the EPA have taken to court and have been the court has decided that they need to stop. And it just showed the extent of the operation activities. It showed that the EPA had been investigating for a number of years. It showed the amount of peat that was being cut. It showed photos like this of the scale that the two companies have been operating without licensing permission, without planning permission. And it showed in black and white terms that the authorities were starting to do something about it, that the EPA was investigating, and that we had a reason to be looking at these particular companies for their activities. So that really helped us tell the story, because this is private land as well. So I can't go access it without trespassing. I can't take the photos. If I put a drone up above it, I still probably wouldn't be able to use that drone footage, even if I could try to justify in the public interest. The defamation and libel, like the laws in Ireland legally, it's very restrictive in what you can do. You really have to tick every box to make sure your story is 100% correct. And this incredibly helpful to our investigation. And we were the first and only really so far to put out information on these particular companies and the activities that they were doing without licensing or planning permission. And this allowed us to do an entire 10-part series investigation. And AIE was integral to that whole thing. I'm quickly going to go through the second example, which was one we did last year on plantation forestry in Ireland. So we're basically looking at the environmental impact of our forestry policy. Again, lack of public records was a big issue for me. There was no information on environmental assessments done for forestry licensing. online. There is no minutes of, say, really important meetings over the years about forestry policy, about maybe the impact of plantation forestry, these conifer forests that we, it's very well acknowledged they have an impact. And there's a real disjointed forestry licensing data system. So the Forestry Service do have information on licenses online, but they're broken down like by certain months. They're very hard to find on the website in the first place. They're broken down by months. They're in PDFs. So they're like, they are in Excel or a database somewhere, but the department puts them in individualized PDFs every few months. You have to click a million times to get one record. You have to then try to change the PDF into an Excel. So there's plenty of issues that for any normal person, like even including myself, you could just not do that. So I knew there was a different way. So they were obviously part of a database system. So I asked to access information on the environment, a copy of the latest licensing database system to include, like, if there was an environmental assessment done, if it was screened out, what size of the forest, all that information. And I got back this, I cleaned it up a bit. There's some of the names were different and stuff. It took a bit of time to clean it, but essentially I got this, which basically means the department have this information themselves, but what they were putting out was just way more complicated, disjointed, and you couldn't analyze the information. So we got, this is a small snippet. It was thousands and thousands of rows, like, I don't know how, 30 something thousand forestry license applications that we got information on through AIE, which then allowed us to actually say, well, if the department won't do a database, let's do our own. So if you're living in Sligo or Cork or Laois or wherever, you could go to our website then, put in your townland or your county, or if you had the reference number, and check for these individual forestry sites, how much, what the site size was, and if an environmental screening was done or not, and if an environmental assessment was done, because the department aren't providing that information publicly in this easily digestible way, which I would argue they should, because they have the information and they're starting to do it now, but it's quite late in the day. We were also able to use that data to do an analysis to show the public that actually, license applications and approvals have been falling over a period of time, which was quite contradictory to what we actually expected to find, because there are these massive roadblocks building up because of the archaic system that's in place, essentially. And through it, we were also able to show that, there wasn't really much public information available on how the Forestry Service were doing their environmental assessment, or these appropriate assessments. They're basically another form of environmental assessment that they have to do. They weren't really saying how they were coming to this determination that about in combination or the cumulative impact of all forestry projects together. So they weren't really telling us, say, someone applies for a forest in one townland and there's already a few hundred acres of other forest there. In 99% of the times, they were saying, well, there's going to be no cumulative impact from all those forests together, even if this one is built. And I couldn't really understand that just didn't make sense. So we asked for any sort of internal reports, any presentations, any briefings on how they came to determine their in combination impacts. And essentially we got a presentation from the Forest Service that said their interpretation of the law is that if we think that site on its own isn't going to have an environmental impact, then it's not going to have an impact in combination with potentially hundreds of other acres. So even if this is the only spot of maybe biodiversity rich land left in the area, if it goes and we say it's not going to have that big of an impact, combined with the others, we're also going to screen out the whole impact of all of that together as a big chunk. And we put that to Antashka and other environmental groups and other legal experts, and basically, their coming back was clearly, this is totally not in line with the legislation. So we were able to actually provide that information back to communities and NGOs and legal experts who would also be interested in this issue, but didn't themselves have a full understanding of why the department were making this decision. So those are just two examples, but like I use it in every single investigation I've done on the environmental area. And I'd say in 8 out of 10 investigations, they're all hands down the most important part that give me the information I need, that we can reveal it's all coming from the environmental information, because I shouldn't have to reveal it, because a lot of it should be publicly available, but unfortunately it's not. So now I'm going to give you, because I have about 5 minutes left, so this is going to be a quick section, so don't worry, on how you send it, because I don't want to, like, Eoin gave a great overview of like the actual, how it works, what it's all about. So now I'm going to do like the sort of dumber journalist version of like, here's how you press send on a request. So here is basically sending your own request. There's no A to Z, there's only a few steps, don't worry. But one, the super important thing is, of course, what do you want? So you really need to consider the information you want and why you want it. Because you have to also think, and Eoin can speak to this far more than myself, there's someone on the other end of that who has to answer your request, who has to go look for all those documents, has to go talk to people in different units of a department or a council, has to go look through files, has to determine if there are exemptions, has to determine if they have to ask third parties, if they need to redact information. You're taking up the resources of the public service. So you don't want to be wasting your time. While, of course, the ethos is there should be transparency, you don't want to be sending a request and getting documents back and then be like, oh, I don't know, I don't think I even wanted this. I don't even know why I asked for it in the first place. That's just a waste of resource. That's a waste of their time. It's a waste of your time. And so you really need to be making a request for a reason. I'm sure some people on the other end of my request sometimes think, why the hell are you making this? But I try to say, like, I always try to explain to them, this is my thinking, and this is why it's an important document for me to get. So think about what you might want. Is it minutes of a particular meeting? Is it minutes of a steering group that aren't publicly available? Is it minutes of a committee? Is it briefing papers that someone might have given to the CEO of the council about a particular issue? Is it briefing minutes to a minister about something? They're usually really, really simplified, short documents, but like with rich detail that might not go public. It might be briefing documents before a big meeting between the EPA and the minister about a very, a pollution issue or something like that. So the briefing notes will give the minister all the details he needs to know that he probably won't say publicly. But for this private meeting, the information might be there. There could be internal audits that you might be looking for. There could be particular data streams. Now, you might be looking for data, like I was looking for data on the forestry licenses. You might be looking for inspection reports or investigative reports, like those EPA Peat site investigative reports that I showed you an example of. So just think about, there's like, as Eoin really showed, it's really broad. There's lots you can ask for, like cost benefit analysis, things like that. There's loads of sort of documentation, emails, text messages, things like that you can ask for. So just think about what you really, really want. Then you really think, who are you going to target? So select your targets. Who are you going to direct your request to? Consider multiple sources, like Eoin used the example there. He sent them multiple. I often send them multiple. So it could be different departments, different state agencies, semi-state bodies, local authorities, anyone who has a remit. And there should be a list. There's a list for FOI. I'm not sure there's a defined list, but on our Noteworthy website, we have information on this. But it's basically any state authority. Anyone who has a state remit should be open to this. So then when you have that defined, what you're looking for, who you're going to target, then you want to send it. So you want to give your name and your contact details. That's the most important. That's an important part. Just your name. Sorry. State you're making the AIE request. That's important. So say you're making this request under the AIE regulations. Be specific. Like I said, be as specific as possible about the information you want. Specify the format. I always ask for an electronic version. It's the best. You don't want the postman coming with a big pile of documents to your door, especially if it's a printed off Excel spreadsheet, excuse me, which has happened to me. So specify the format that you want it sent back by email. Request it's provided as soon as possible, but it's going to be 4 weeks, which is the limitations, 20 days they have to provide the answer. And always request an acknowledgement letter as well. So they send you back, this is the person handling your request, here's the deadline. Then you want to mark your calendar. This is super simple. I'm not going to, you can make a master spreadsheet like I did if you're going to send lots of requests. Otherwise, mark when you send your request, mark 20 days on in your calendar. This is when my case is due. That's the most important thing for you to know from this. And follow up. Like, you don't have to, but I really advise contacting the officer dealing with your request. You know, like I said, the acknowledgement letter will tell you the contact details of who is handling your request. Leave it a week after you send it, or like 10 days, and then follow up and say, hey, I'm just looking to follow up to see if I need, you know, do you think I need to refine my request? Is it clear? How is it progressing? Because you're essentially telling them, like, politely, I'm not going away here. I'm following up on my request. So you're like, don't ignore me and hope that I just don't say anything. And then after 4 weeks, you'll always refuse because it was too broad. Because you'll go, well, why didn't you tell me? I would have changed it. So sometimes it's up to you to go back and sort of push the envelope there. And really important, I mean, you can use a spreadsheet and stuff you want, but really only if you're making multiple, get everything in writing. Super important. Don't have a phone conversation and just leave it. Send an email to say, as per our discussion, da 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 da. So follow up afterwards by writing if you're talking on the phone with someone. And then you get to deadline day. You should get a letter. So you should get an email back with an attachment, say, outlining the decision-making process. It should tell you if there was refusals and, you know, the reasoning why. You should get a schedule of all the records, if they're released or not. There can be several outcomes. In the perfect scenario, you get everything you wanted. And like me, you do the biggest investigation. You mean like the Pulitzer Prize, it's probably not going to happen. But oftentimes you will get some of the documents you want. You might get some documents redacted. There might be a request for an additional month, and you might be refused. So just be prepared for all that. It's not your fault. If you're refused, it's not necessarily your fault. There could be a poor decision, or it could be legitimate exemptions in there. So really quick last slide, because I'm 2 minutes over. If you're refused, just like, it's okay. Just make sure to examine the decision letter and make sure that any refusal is justified by reference to the AI regulations, right? So you need, like, you shouldn't just take a refusal as, oh, that's fine, I messed up, or, oh, it's legitimate. Check if it says it's exemption 11.2a, whatever, or 10.10, 10b, part 4. Don't just go, oh, I wonder what that is. Go look at the AI regulations and go to that Article 2 or Article 10, whatever, and see, I don't think that's really justified. I don't really agree with that decision making. Like, I don't think that's a justifiable reason for refusal. And see if there's any arguments that you can make back in an internal review process. So you might feel it's justified. If there's excessive redactions, you know, that might be another thing. You might think, okay, that seems excessive for the document and how important it was and the reasons why they refused it, you mightn't agree with. So you have an internal review option at that stage. If you're not satisfied with refusal, you can say, and you don't even have to justify, you don't have to give a big long list of reasons. You can if you want, but you can just say, you know, reply, thank you for my FOI decision. I now wish to request an internal review. Thank you. It's free. There's no fee for it. Then there's just an extra 20 days and someone else, a more superior officer, will deal with your request as if it was new. And it's hit and miss. Oftentimes they'll just agree with the previous decision, but in some cases I've had decisions overturned and documents released to me that turned out to be really important. So it's an option, and I would use it if I were you, if you're unhappy with the decision to refuse in the first place. If the internal review doesn't go your way, you can go to the Office for Information on Environmental Information, the Office of the Commissioner for Environmental Information. There's a €50 fee. You do need to provide a lot more detail to this. It has, because there's more of a legal argument to play here. I would only go to this option if it's really, really required, because it can take up to a year to get a decision made. And I don't know, sometimes they're good, sometimes they're bad, as Eoin will know more than me, and with Fred Logue. Sometimes the decisions are great, sometimes you're just baffled by the decisions that are made in favor of sort of the public authority. But yeah, that's if it's refused, basically don't just give up on the process. There are options afterwards. So if anything was unclear there, ask me some questions now and we'll go through. But it's final word, because I know I'm over. It's a super powerful tool. Use it for, you know, if you're involved in community environmental groups, if it's your own situation, if you have contamination or air pollution issues, or something you're going on your local walk and you see trees being cut down, or you see some contamination, if you're unhappy with the decision-making process somewhere in the county council, These are great tools to use all the way up to, as like I would use it as a journalist for revealing, like revealing big parts of my investigation and hoping that something changes, and then all the way to Eoin's case of actually, getting legislative legal cases brought through the courts using environmental information in those cases. So it's a super important tool, and I really hope you keep in touch with any questions. Even after this, I'm happy to answer. Thanks very much.
Thank you so much, Niall. That was brilliant, and really important, the work that you guys at Noteworthy are doing in making the information you're finding actually meaningful and accessible to people, that it's not just raw data that can be really hard for the average person to interpret. So we have some really brilliant questions coming in. We actually have an awful lot of them. I'm not sure we're going to get to everyone's questions, but we'll do our best. One interesting one that's come in is from Owen Clarkin. He asks if there are any suggestions or advice for submitting AIE requests to other European state bodies, so non-Irish bodies, and are all semi-state bodies open to AIE requests? So I'll put that to either of you.
Yeah, do you want to go on, or I don't mind?
You go ahead, Niall.
Yeah, no, I think like Owen might be able to speak to this actually more than me, but from my experience, there is there's more like an FOI equivalency in, say, like the European body. So like for European Institute, the European Commission, different elements of the European apparatus, there is like an equivalent version of this, but there are fairly strong exemptions. But I've received information from that. Say if I'm looking for maybe correspondence between an Irish department or the Irish state and a Department of European Commission on, say, peat extraction stuff, they have released documentation to me that the government have to be very honest and clear in their reporting to the European Commission. So sometimes you get really rich, detailed information, but any country that has signed up to the Aarhus Convention, which is pretty much all of them, definitely in Europe, they will have a version of AIE. So I've sent a few to to Denmark, about the Danish power station, using their equivalent of AIE. So you just have to basically Google it to see if there's the equivalency. That's what I do. There might be a different way, and all semi-states should be open essentially to AIE requests, but there's a whole thing developing now of subsidiaries of semi-states who are, I would say, hiding from their obligations under AIE by using these subsidiary structures, even if they're 100% publicly owned. I've had a lot of refusals now from Bord na Móna subsidiaries. Bord na Móna refusing because they said the information is held by their subsidiaries who don't believe they fall under AIE. So that's a whole new thing developing. But in theory, yes, they should be, and all their subsidiaries that they have 100% or near 100% ownership should be, I think.
That's great. Thanks, Niall. I might come to you with a different one now, Eoin. Someone has asked, why aren't people more aware of their environmental rights in general? So why is it that people in general don't tend to know that they have a right of access to information? And have there ever been legal cases taken against public bodies for refusal to grant information?
Oh, well, I'll start with the first one. The second one. There's been a lot of cases, and particularly in the last, I would say, probably 7 years. Now, obviously, the AIE regulations are around many years, but it's only in the last, let's say, 6 or 7 years that things have really kicked off in terms of the knowledge there, and it's still not really widespread, but I think it's becoming more widespread of how powerful the AIE regulations are. So there's been a series of cases taken by individuals and that entity I spoke about, Right to Know, that have really pushed things forward in the courts, and then that has a sort of another knock-on effect. So like what Niall mentioned there, Bord na Móna, it's a case in point, where they are setting up these subsidiary companies, and Bord na Móna has a huge land base, and their actions have a real significant effect in terms of drainage of bogs and affecting biodiversity and so on. So there's actually a case coming up in a couple of weeks' time where basically to do with Bord na Móna subsidiary, Bord na Móna Energy, where Right to Know have requested information has been refused on the basis that it's this other entity that's owned by the state. So it's a very interesting case coming up in a few weeks, as I say. So the whole thing is that the case law, I think, is quite critical in then shifting things basically to requesters, that you can rely on decisions that have been in the courts and so on. Sorry, the first question in Clodagh, which was
just why do you think people aren't more aware of their environmental?
Okay, the thing is that unlike FOI, which is more of a general concept that's been around longer, and even internationally, the whole idea of freedom of information internationally, access to information environment hasn't been sort of got the same purchase. And another issue, I think, is that a lot of our state companies are actually exempt from FOI. We have all these kind of partial exemptions and so on from FOI, and I've seen this working for public authorities, some of which would be exempt from FOI but are under AIE. And the thing is, I actually think that having entities under FOI, because I've seen the both sort of ones where they're in a FOI and they're in AIE, it creates a cultural change within the organization, because the organization at a management level realizes that everything that they do that permeates through the organization can be potentially out there, and in worst case scenario it'll be in the Sunday papers or on Niall's website and so on. So it creates a cultural change. Those entities that are not under FOI, my observation is that there is a mindset often within those public authorities of resistance to transparency. And it's a cultural kind of thing within the organization that, look, we're in it here against those people looking for information and trying to bring us down and so on. So I think there's a wider thing around access to information as a democratic concept within the society, that the citizens should have access to information, that what is done in their name should be done behind a glass pane, and people can see what's going on. And that goes back to what I was saying at the beginning of my talk about this proactive dissemination. Like, we shouldn't have to be making all these AIE requests and dealing with, as Niall was saying there, having these, public servants going off, and putting stuff together and talking to people. Just put it out there in the internet. It's really, really easy. All these documents are PDF documents and so on. Put it out there, you know what I mean? And just have this proactive dissemination policy. Someone can click there, and see what's going on. And it just is, it helps then, I think, that to break down the thing, that there's a thing that it's not just some kind of a shady kind of deal has been done and so on. Like, I've seen that as well. Like, again, where I was working for public authorities, where something was really, there was no kind of smoke and mirrors or anything. It was just people doing an ordinary job, public servants. And, but somebody, because there's a lack of transparency within the organization, people think that such and such a deal was done for shady reasons when it wasn't, and so, but for that organization, if they just kind of put it out all there from day one, put out their systems there, then it builds a confidence there amongst the public about what's going on. I think that's an important concept for our democracy generally. But that's another thing.
Yeah, could I just add on what Eoin said? I think that's really true, because sometimes you'll see, and like, we're guilty of it, and other journalists as well, that you go looking for documents and they come back, and then you're like, okay, we can reveal, or we can show that, like, these minutes of a meeting which were not public show the real decision making, or whatever it might be. Like, if they were on the council's website or the department website regularly, which should be done for any sort of steering group or committee or meeting, you probably just read through it and be like, okay, this is great, it's transparent, the decision-making process. But because it's not out there, and then maybe 2 years later you go looking for it, and then you see it becomes a much bigger thing. So it is it's that trust that's built up. And I think, like Eoin said, there wouldn't be maybe so many articles and people getting annoyed if the documents were just out there. They'd read them and say, okay, this is actually, I don't agree with it, but at least they were transparent about it.
Thanks so much, both. I think that's such a good note to end on, that AIE is not only a critically important right, but it's also so important to democracy and to good governance in general, and to social trust. Unfortunately, we're going to have to bring the webinar to a close. Thank you so much to everyone for the questions, for such an engaged Q&A session. And I'm really sorry to people whose questions we didn't get to today. I've put Eoin and Niall's Twitter handles in the chat box so you can follow their work online, and please do. Thank you so much to Eoin and Niall for such fantastic presentations, and you really made it really accessible and practical. I think I can speak for everyone here when I say that. So thanks so much. And just to remind everyone that today is the first in a series of 3. The next webinar is on public participation in environmental decision making. So that's next Tuesday, again from 9:30 to 10:30, using the same registration link. So please do share that with your networks. And in order to understand the full kind of potential of environmental rights, we'd really encourage you to attend all 3. So the final session will be on Tuesday, the 18th, and that's on access to justice. So hopefully see you next week, and thanks again. Okay.
Thanks, everybody. Thank you.
Thanks, everyone.
Bye.